Thank you, and I would like to welcome Minister Burton to the House. There are many commendable aspects to this legislation. The first, Section 3, deals with the payment service providers and change in legislation allowing the Department to enhance the services it provides and their proper supervision. Contrary to some of the commentary, the Government has absolutely no intention of denuding the Post Office network. This morning I received correspondence from the IPU and they have stated that they understand they cannot be included in name in the legislation, and I would like to put on the record that An Post is specified in the regulations of this bill. On the contrary, the Government our wish is to reinvent and modernise the Post Office network. There has been absolutely no announcement or legislation allowing for the closure of post offices in the near future. The Government is committed to protecting the existing network insofar as possible. As recently as the 25th of February, the Government made this clear by announcing a whole-of-government review as to the nature and amount of services that can be undertaken by post offices as a front office for the state. The intention is to have the post offices doing more, not less. The Cabinet Committee on Social Protection is in the midst of their consideration of these issues and is due to report in September, it's hoped. Fine Gael completely understands the concerns of the Postmasters Union and indeed met with the IPU to discuss them and consider how best to ensure the future of our post office network. As to the opposition charges that we are intent on dismantling the network, I want to state the following very clearly. In 2010, the last full year of the last government, 72 post offices were closed. Only 17 have closed since then. We have one of the most extensive post office networks per head of population in the EU. We are fully cognizant that 2/3 of post offices are in rural areas, providing a much needed and welcome service. Senators should be aware that An Post recently won a competitive tender process run by the Department of Social Protection for the provision of over-the-counter cash services for social welfare customers. This contract is worth more than €50 million annually to An Post. This is over an initial 2-year duration and can be extended to 6 years. Every party and senator in this House knows, or should do, that the post offices are considered a network of commercial businesses under EU competition law. No government, no matter the composition, can guarantee that An Post will forever win such tenders. An Post is a commercial state body and the rules apply to them as to any other. They are free to bid for any business of a public or private nature in a competitive market. I'm going to go into some detail as to the EU legislation position regarding An Post and the Department tendering in order to dispel any doubt. Following the Government decision in 1999 to extend the An Post contract for the delivery of social welfare payments for a further 3 years, a complaint was lodged with the European Commission under the Procurement Services Directive. On the 20th of December 2002, the Commission issued a reasoned opinion against Ireland. The opinion recognised that the only obligations imposed in relation to the services were the prohibition of discriminatory technical specifications, and that the result of the award process must be sent out to EU Official Publications Office. This has been the argument put forward by Ireland. However, the Commission also felt that in addition to these obligations, an awarding authority should respect the EU principles of non-discrimination, equal treatment and transparency. These additional conditions would compel the Minister to advertise the payment delivery service of on a European-wide basis and to uphold the principles of non-discrimination, equal treatment and transparency in the awarding of any contract. The Department, in consultation with the Office of the Attorney-General, rejected the reasoned opinion on the 19th of February 2003. The case was referred to the European Court of Justice on the 1st of December 2003 and a hearing took place in Luxembourg on the 4th of April 2006. The Advocate General of the Court gave an opinion on the case on the 14th of December 2006 that upheld the European Commission claim that Ireland breached competition rules by not publicly advertising the An Post contract. The opinion concluded that the Court should declare that in deciding to entrust the provision of services to An Post without a prior notice, although there were no circumstances which would have allowed no advertising at all, Ireland had failed to comply with its obligations under the EU Treaty. Additionally, in her opinion, she stated that the Commission retains the right to take further action against Ireland under Article 228 EC if it feels there is a delay in implementing the judgment of the Court. The Court issued its judgment on the 13th of November 2007 and ruled that we did not breach EU rules. The Court stated that in entrusting the provision of social benefit payment services to An Post without undertaking any prior advertising, Ireland has not failed to fulfil its obligations under Articles 43 EC and 49 EC and the general principles of community law in connection with the contract for the supply of such services. However, this was a win on a technicality. In its judgment, the Court said that the Commission had failed to provide sufficient proof that the welfare contract was of interest to companies located in different Member States. It also found that the Commission had failed to prove that any interested parties would have been unable to express their interest in the contract because they did not have access to relevant information. The ruling maintained that a mere statement by it, that is the Commission, that a complaint was made to it in relation to the contract in question is not sufficient to establish that the contract was of certain cross-border interests and therefore a failure to fulfil obligations. The Court concluded that the Commission had failed to provide sufficient proof that the contract in question was of sufficient interest to firms across the community, but this was a failure of proofs, not of the legal argument presented by the Commission and endorsed by the Advocate General. The Commission's action was dismissed. While it was a technical win, the Court stipulated that if the contract is of sufficient interest to firms in the community, then any contract must be subject to a degree of advertising to alert the EU market and allow firms to be given an opportunity to express an interest in obtaining the contract. As can be seen from what I've stated, the State are in no position to do anything but advertise and tender for payment contracts from the Department of Social Protection, and they have been tendered and advertised ever since. No government is in a position to, as some of the opposition seem to think, to snap its fingers and magic contracts into the hands of An Post forevermore. The post offices have completed a programme of complete computerisation and should be in a very good position to provide front office services for the State post the present review. It is also uniquely equipped to do so for the financial services sector generally. However, they must go out and seek new business like every other company in the State wishing to maintain its presence. The Government and Fine Gael will provide every legal incentive and support to An Post in doing so, but it cannot do everything. An Post need to innovate and provide new and demanded services. The second aspect of this bearing employees that have been in operation since 1997. This intervention has the intention of giving Irish operators the same advantage insofar as possible as their competitors who use low labour costs. Or low-cost labour. This restatement or clarification in Section 6 of the Bill in order to bring matters into line with EU state aid rules is appropriate and necessary. Thirdly, I welcome in particular Section 7 of the Bill whereby an employer qualifying for a refund of PRSI while owing a debt to the Minister due to non-payment of statutory redundancy will have that refund offset against the debt owed. Section 8 is a welcome tightening of the regulations in relation to the qualifying adult of a claimant who is not resident in the State or in prison. This would seem to me to be common sense and I would welcome it. Such a restriction, as the Minister has noted, will not prevent an ongoing claimant receiving such allowance or assistance as they are entitled to, as long as they remain in the State or are not in prison. Section 11 also provides a warranted tightening of the habitual residence condition. And finally, this bill enables the Youth Guarantee Scheme by enabling very limited age discrimination, a discrimination aimed towards a legitimate goal, that is the provision of employment schemes to our young people. And in closing, I would like to commend the Minister for a good piece of legislation that adds to your quality of work over the last 3 years. Thank you.
Thank you, Senator.